This is Nick Wooten with Consumer Trial Lawyer Academy. We left off last talking about closing arguments and arguing damages, and wanted to talk a little bit in particular about arguing punitive damages and a number of theories that we've thought about and spent a lot of time on over the last few years as we've dealt with sort of some of the rulings that have come down. As we sit here, we're at the beginning of December 2023. We had the verdict in the Sacramento case where Judge St. Evil in the Seventh Circuit said, "Hey, great, Ocwen's a terrible company, but," and cut the punitive damages 1-to-1. Didn't give us an opportunity to have a new trial, which we would have jumped all over based on what we later found out about how much Ocwen had withheld from us in that case, and also sort of the points of emphasis that came down out of that appellate decision that would have really strengthened our hand, we felt like. So, you live and you learn. You take those lessons and you do the best you can to try to get better outcomes for your client the next go round. Not that our client was upset at the end of the day with her recovery. We were very upset about what we thought was an injustice towards the public in general, because quite frankly, when you let a big company off from a punitive damages award, you're simply encouraging them to go back and do the same thing again because they have a clear picture of what they can get away with, or what they think they can get away with. So, we argue punitive damages as aggressively as we can. We also try to attack the existing rationale that came on the scene around late 90s, early 2000s, when the Supreme Court suddenly decided that it was okay to disregard a jury's verdict, which it had never done before, as to the damages award. And so there are a lot of lawyers out there nowadays who don't even remember when it was impossible, essentially, to attack the amount of a jury verdict. That is a creature of the tort reform movement. It's only been on the scene since the 90s. About the time that I went to law school was about the time that BMW versus Gore was decided. And quite frankly, the current iteration of the U.S. Supreme Court is such that if they're intellectually honest, they couldn't affirm any movement to limit punitive damages based on some of the holdings they've already expressed. It was interesting, the Dobbs decision that overturned a woman's privacy rights. Justice Thomas made an interesting observation about how this entire notion of certain rights that would have been covered by Dobbs were in effect in question. Well, guess what? The same rights that women supposedly had prior to Dobbs are the same rights that corporations relied upon to create their entire tort reform jurisprudence about limiting punitive damages. So, in theory, should be open season on some of those same faulty logic that was used to create a defendant's rights to challenge punitive damages awards. So it's very important to get good help on the appellate issues if you don't know them very well yourself, but you can never have too much help on appellate arguments. And you have to think about what appellate arguments you're going to be dealing with if you're successful with your punitive damages argument. Ratios are always out there, but truthfully, when you're talking about multi-billion-dollar companies, any analysis of ratios for compensatory purposes eliminates any deterrent effect of a punitive damages award. It's just, when you have someone who gets a $1 million compensatory award and the company makes $5 billion a year in net cash, any punitive damage award tied to the $1 million is never going to be enough to impact corporate behavior. So Again, we spent a lot of time on this issue getting ready for our recent case against Wells Fargo, because that's a classic example of a defendant who is financially nearly untouchable. We were arguing that any punitive damages award that wasn't in the billions of dollars would have no effect on Wells Fargo. That was because Wells Fargo, just their deposits, what they earned from the money they paid their depositors versus the money they made overnight with the Fed, their net interest income, as they referred to it, was on the magnitude of $200 million a day. So, we were in a situation where in a 5-day trial, Wells Fargo was going to make $1 billion of income just for being smart enough to open the doors to their bank every day and, close them up at 5 o'clock. That's just one category of their income. It wasn't all their income. And so, our argument to the court in that case was that, any punitive damages award in this case would have to exceed, to have any impact on Wells Fargo, it would have to exceed at least their net interest income for the time they were in trial, or they would have made money while they were in trial for what they'd done to our clients. And, it seemed to resonate with the trial court. Obviously, we didn't go all the way to verdict in that case, so we don't know how it would have resonated with the appellate courts. But, the thing that we have to think about is within the current framework, the magnitude of the harm to the consumer. Your stories have to be compelling. For instance, in our case, we had clients who were, never going to recover economically from what had happened to them. And that wasn't our words, that was the words of the Federal Reserve. I mean, they had said that people who lost their homes during the financial crisis were unlikely to ever recover economically during their adult lifetime. And our clients were at an age where they would have normally begun to start thinking about retirement and things like that, but they had, the credit, the worst type of credit you could imagine. I mean, they were subprime, beyond subprime, thanks to what had happened to them, thanks to what Wells Fargo had done. And they had been that way since they'd lost their home. And that was all because Wells Fargo had a problem with their computer software and didn't do the math right and didn't offer them the type of, loss mitigation that they were qualified for under the federal programs. And that led to foreclosure and bankruptcy. And that double whammy pretty much, made it clear that they were not going to be able to ever get back on their feet financially. And so they were just one couple out of hundreds of thousands of people who had suffered the same way at the hands of Wells Fargo. So you had massive injury to the actual plaintiffs, but you had massive injury to everyone that had suffered at the hands of this mistake because of Wells Fargo. And then you had a series of consent decrees that went on for more than a decade, where Wells Fargo promised various regulators that they were going to clean house and get things right, do what they were supposed to do, and they never did. And they had been fined already billions of dollars in this area, just in mortgage servicing, not counting all the other things that we know about from Wells Fargo. And yet the problem persisted. And yet the problem was not completely cured even after 10, 11, 12 years. And so you had recidivists engaged in more than a decade of wrongdoing, thousands to tens of thousands of people affected by this issue, and, no sign of change from Wells Fargo at all. No sign that it ever would change. And so we felt like we had a perfect storm there for a punitive damages award that, would be enough to get Wells Fargo's attention. And we had intended to ask for a massive punitive damages award. you know, those types of things, you really have to get that type of evidence in your case, and you have to make sure you formulate that argument very early so that when the judge looks at you and tells you you must be crazy if you think there's going to be $1 billion verdict in your case, you have to explain to the judge why you think you'd be crazy if there wasn't $1 billion verdict in your case. And you have to be able to do that, obviously, with the right amount of respect and decorum. But, you know, we made a very compelling argument that it would take a massive number to have any impact on a beast the size of Wells Fargo. And, you know, we'd stand by that argument in front of anybody. It's all very relevant, right? I mean, if you enter an award of, you know, $1 billion against me, well, woohoo, you that's about $1 billion too many to break me if what you're trying to do is get my attention. But when you're talking about a company that makes nets hundreds of millions of dollars a day just by opening the door to its banks and doing normal banking business, I'm not talking about investment banking, I'm talking about just consumer banking. Billions of dollars a week just for opening the bank's doors 5 days a week. You know, it takes a lot to affect the bottom line of a company that size. And, you know, we have to be bold enough to explain why those numbers matter in the context of the particular defendant we're dealing with. And then, of course, you've got to be able to explain that in the context of your own case and who you're after. It doesn't do you any good to get $1 billion verdict against somebody who's only worth $1 million. By the same token, it does you no good to get $1 million verdict against somebody who makes $1 million every quarter of a second. You've done nothing to them. They just laugh and going down the road. So punitive damages always have to be calibrated to the size of the defendant and what it takes to actually create any deterrent effect. You know, for some people, $50,000 in punitive damages is way too much. And for others, $50 billion isn't even a good start. So you got to find out where you fall on that range and make sure that you're able to explain why those dollars matter in this case. And you've also got to build your evidence on punitive damages around getting the right materials in front of the jury when it's time, you know, to get that stuff out there. And you've also got to be conscious of the fact that you can't make it all about the size of the defendant. I mean, you know, in the case we recently tried, we actually were not opposed very strongly to bifurcation because we did not want to be in a situation where there was an argument that the size of the defendant sort of overwhelmed the rest of the discussion. And, you know, that also requires calibrating your trial presentation as well. But that's sort of a separate topic of talking about bifurcation versus unbifurcated proceedings. It's much cleaner and easier if you don't have bifurcation, but sometimes you have to think about why bifurcation might be the best thing to do to present the cleanest case for appellate purposes, especially where, you know, you're still going to be able to get in all your evidence about things like consent decrees and wrongdoing in your case in chief without ever really talking about the dollar amounts of punitive damages that could be in play until there's a bifurcated portion of the case. When you think about your punitive damages, number one thing to consider is, you know, how do you calibrate that in a way that makes sense? And really the discussion, the thinking there is more along the lines of what are you going to have to say to, if you're in federal court, obviously your circuit court of appeals. When you stand in front of them to defend your verdict, you know, the arguments you're making to them should be arguments that you developed long before you're standing there. You should have already had this argument fairly well developed for the trial court, if not completely developed. And in fact, if you're confident in your case, I would say, you may want to have it sort of already in the pocket at the outset, so that you're able to talk to the judge right out front about why it's a punitive damage case, and why it's a big number case, and why you're going to be asking for what you're asking for, and why that is constitutional, because you're going to get you're going to get some incredulous looks, and if you're not prepared to answer those questions, then those looks may turn into rulings. So make sure that, if you're dealing with a massive defendant and you're going to be asking for a massive number, then make sure the first time you walk into court or you get on a conference call with the court, and the defense is going to bring that up and say, well, they want this ridiculous number. You need to have a 30-second answer that puts a cap on that issue for you, and makes a strong argument that the defense really is not going to be able to respond to very well, about why, yes, you are asking for what looks like a massive number, but when you put it in the context of this particular defendant, it's actually only, it's next to nothing. And that's some things that we were able to do. We were able to draw comparisons to the idea that, hey, $1 billion, it would take more than $1 billion for this company to lose a penny for going to trial with us. And I mean, if they don't even lose money while they're going to trial, then how can they ever say they've been punished? If they're able to go to trial and still be profitable for the time they're in trial, they certainly can't claim that they've been punished. So, those are the types of things that matter. Those are the types of things that you need to have handy. And that's why it takes going through sort of the existing state of the law and coming up with the argument for why the dollar amounts that you'd be asking for in this case are necessary and relevant for the purposes of punishment and deterrence. The more obvious evidence you have on the front end that's indisputable about things like consent decrees where these types of things are admitted, or opt-outs from a class action where the conduct is admitted, that type thing, or CFPB findings of wrongdoing, things that will be hard for the defendants to, claim are not relevant to the consideration and discussion. So, when you've done that homework to get yourself in a position to make those arguments, then in essence, when you're arguing that to the jury, you're going to have the same type of explanation to the jury is, the reason that this number is the way it is because we're here to punish and deter the defendant, not because my client wants to buy an island in the Caribbean. We're here to make sure that this defendant is punished in a way that they stop doing this to people, and it's not profitable to do this to people. And you have to have the focus on why the money is necessary to punish and deter, not the defendant argument that your client is looking for a lawsuit, lottery, mega windfall, because that's just not the case. I mean, awarding $1 million against a company the size of Wells Fargo would be no different than winking at somebody on the street that just robbed the bank. I mean, it has no effect whatsoever. You have to make sure that you're, the old saying, the punishment fits the crime. And when you're talking about punitive damages, that's always correlated to the wealth of the defendant that is there and what it takes to actually get their attention financially. There are lots of companies that a lot of money runs through the company every year, but they are on a tight margin. So it wouldn't take as much to punish a company that's on a tight margin and doesn't have much net profit. But when the net profits are in the billions or hundreds of billions of dollars a year, it takes zeros to get those folks' attention. That's the only thing that does get their attention. It certainly isn't You know, 7 figures ain't even a good start when you start talking about somebody that's netting tens or hundreds of billions of dollars a year in profits. It ain't even a blip on the radar. It's a rounding error. So if you really want to impact them, you got to get beyond the rounding error and get to something that they actually got to stop and pay attention to. And that's where the strength of your argument lies, is that, you know, Judge, this ain't the freaking 60s. And these companies are worth zillions of dollars, and they got zillions of dollars on hand. And if you don't pinch it a little bit, you've had no effect at all. So make sure you've done your homework on that. Make sure you know what it's going to take to get anybody's attention, and make sure you can explain why the numbers you need to talk about to the jury are the way they are, and how that still fits within the constitutional structure that we're currently operating under, what's been decreed constitutional. And be on the lookout for those cases challenging the current structure, because I promise you they're coming. You know, we've gotten to a point where corporations have more rights than normal people, and that can't persist for very long without there being a problem. So keep those things in mind as you're looking at these issues. You're getting your cases ready for trial. Make sure you stay in contact with folks who are litigating these issues and the folks who are fighting these fights on the appellate levels, because there probably will be some fluidity in these areas over the next couple of years. So, and, you know, unfortunately, because the way the legal system works, we have to think in years and not days and weeks. So anyway, I hope this is helpful. Again, thank you for your time. This is Nick Wooten with Consumer Trial Lawyer Academy. If this has been good, useful, helpful, please like and subscribe. And also, please feel free to leave any comments that you might have about any other areas or topics you'd like for us to talk about. We look forward to having more sessions with you and bringing more useful content. Thanks, and have a good day.